All right, everyone, let's get started. I'm sure some more folks will trickle in. But again, like I said, I know folks have limited amount of time. So good afternoon, everyone. I want to welcome you all to this Section 504 webinar presented by the Massachusetts Charter Public School Association and Krokidas Bluestein. My name is Bettina Toner. I'm a partner at KMB. We want to thank you all for joining us to learn about Section 504 of the Rehabilitation Act of 1973. It's always a pleasure co-hosting these learning events with the MCPSA. Section 504 is a special place in my heart. I was a civil rights litigator for many years, so I always enjoy talking to folks about Section 504. Some brief housekeeping matters before we jump into the presentation. Wanted to just let folks know that we'll be circulating the slide deck and the link of the recording to today's presentation in the next couple of days. We're aiming to leave time at the end of the presentation. Folks submitted questions with the registration, so we're going to try to get to at least a few of those if we have time. But you can also submit questions during the presentation, either using the chat function, or if you want to remain anonymous, you can submit it through the Q&A function. We'll collect those questions, and the ones we don't get to, we're going to put into an FAQ document, and we'll circulate that as well to folks within the next couple of weeks. Lastly, just a reminder, our standard disclosure that this webinar is for informational purposes only and is not meant to constitute legal advice. Questions about Section 4 should be directed to your legal counsel. That's our standard disclosure. Next slide, please. Before I hand things off to Eric, I just want to say just a little bit about who I am and a little bit about the firm KMB's charter school practice. Again, my name is Bettina Toner. I'm an attorney in the education and employment practice groups here at KMB. I represent Massachusetts public charter schools and other public and private educational entities in a wide range of matters. So everything from student services, special education, employment matters, and related litigation and all of those areas. KMB as a firm has a full service charter school practice. We represent many charter schools, many of you who are joining us today. It's great to have you with us, and those of you who don't know us, it's nice to have you as well. We represent, like I said, we have a pretty broad charter school practice here at KMB, so providing advice and representation in areas including governance, state ethics, contracting, public procurement, real estate acquisition, development, and finance, employment, as I mentioned, and student services, as well as lobbying and political activity. So as I mentioned, I'm joined today by my colleague, Eric Jordan. I'm going to hand it over to Eric to tell you a little bit about his practice and to kick us off with our presentation. Thank you.
Yeah, thank you, Bettina, and good afternoon, everyone. My name is Eric Jordan, and I'm also an attorney with KMB, working with the Education Practice Group, and doing a wide variety of work in the same way that Bettina described, so ranging from corporate governance to student discipline, special education, and regulatory compliance, such as with Title IX and Section 504. If we move to the next slide, please. We have a number of things that we like to review with you all today as pertains to Section 504. We'll start with a little bit of background, then we'll move to some of the requirements of Section 504, eligibility under Section 504, and the components of a Section 504 plan. And then we'll also review a number of additional considerations that you should keep in mind as you're going through a Section 504 process. And so with that, let's go ahead and get started with a bit of background. So when we use the term Section 504, we are referring to Section 504 of the Rehabilitation Act of 1973. And it was designed to eliminate discrimination on the basis of disability. Specifically, the language from Section 504 states that no qualified individual with a disability shall, on the basis of a disability, be excluded from participation in, be denied the benefits of, or otherwise be subjected to discrimination under any program or activity which receives federal financial assistance. And this includes local educational authorities such as charter schools. Section 504 applies to more than just students. It also applies to employees. But for the purposes of today's webinar, we'll be focusing mostly on Section 504's applicability towards students. All right, if we go to the next slide, please. Thank you. So in 2008, there were a series of then recent U.S. Supreme Court cases that Congress viewed as improperly narrowing the coverage of the Americans with Disabilities Act, which prohibits discrimination on the basis of disability in employment and public accommodations and in public services. So Congress responded to that improper narrowing in 2008 by enacting the ADA Amendments Act of 2008, or the ADAAA. Ultimately, the ADAAA had an emphasis on broader coverage for those who might receive accommodations under these disability measures. They amended definitions relating to coverage under the ADA, and they incorporated those new broader definitions into Section 504. It was also the case that there's more of a focus on accommodations and less a focus on scrutinizing whether someone has a disability sufficient to merit accommodations. So the purpose of the ADAAA was to expand that coverage. Okay, next slide, please. So in May of 2022, the U.S. Department of Education, or USDOE, announced solicitation of comments to develop proposed amendments to Section 504. However, new Section 504 regulations have not issued, and they seem unlikely to move forward under the current administration, although obviously we'll keep our eyes attuned to that. We also just wanted to flag kind of relatedly in terms of litigation and the Texas v. Kennedy matter. That was a lawsuit brought by 17 states in September 2024. And those states argued that language from the U.S. Department of Health and Human Services, Section 504 regulations, was problematic. One of the things they highlighted was that language in those regulations preamble dealing with gender dysphoria, indicating that gender dysphoria may be a disability requiring accommodations. That was an element of their challenges. And the states also challenged the constitutionality of Section 504 generally, but that claim was dropped by the plaintiff states in April 2025. The current status of that case is that it is stayed, meaning that it is paused. Okay, if we move to the next slide, please. Thank you. So we wanted to kind of review some of the requirements under Section 504. First, Section 504 prohibits discrimination on the basis of disability, and that includes a prohibition of bullying and harassment on the basis of disability. Section 504 requires the provision of regular or special education and related aids and services, typically referred to as accommodations, to access an educational program. And those accommodations also apply to a student's participation in athletics and extracurricular activities. It's also the case under Section 504 that charter schools must provide those services or accommodations that are designed to meet the needs of students with disabilities as adequately as they would meet the educational needs of students without disabilities. And that concept is free, appropriate public education to which students are entitled. Okay, next slide, please. Thank you. We'll go back one more, please. Thank you. So Section 504 always also requires a public statement of non-discrimination on the basis of disability. That non-discrimination statement should be included in applications and other public-facing documents. There should be a Section 504 coordinator appointed for your school or someone in a similar position to coordinate the school's compliance with Section 504. And Section 504 requires that charter schools adopt grievance procedures that would incorporate appropriate due process standards that provide for both prompt and equitable resolutions of complaints that allege violations of Section 504. Okay, we'll move to the next slide, please. Thank you. So Section 504 is not to be confused with the IDEA, although there are some similarities. But Section 504 differs from the Individuals with Disabilities Education Act in a number of notable respects. So first off, Section 504 is not focused on specialized instruction for a student or about the student necessarily making effective progress in the general education curriculum in the same way that IDEA has a focus. Instead, Section 504 is all about equal access and those reasonable accommodations or supplementary aids that might be necessary to provide a student with FAPE. As indicated before, it doesn't strictly apply to students. It can also apply to employees. It can apply to parents who require accommodations, for example, to attend a child's play. And one of the other things to note is that there are different definitions for what constitutes disability under Section 4 in the IDEA. Okay, the next slide, please. All right, so some of the key features of FAPE under Section 504. And again, the FAPE acronym refers to free, appropriate public education to which students are entitled. So the provision of FAPE would include identification and evaluation processes to determine the appropriateness of Section 504 accommodations, but those identification and evaluation processes must guard against misclassification or the inappropriate placement of students. There should be periodic reevaluations of the appropriateness of 504 accommodations, and there should also be evaluations prior to a student's change in placement. Education services must meet students' individual needs. Students with disabilities must be educated with students without disabilities to the maximum extent appropriate. That's referred to that concept as the least restrictive environment. And it's also the case, as we highlighted in the last slide, the schools must have due process procedures in place should there be any complaints about the Section 504 process. Okay, let's go to the next slide, please. Okay, now under both Section 504 and the IDEA, charter schools have a legal responsibility to identify, to locate, and to evaluate any students who may require special education or related aids and services or accommodations to access FAPE. And that concept is referred to as child find, that responsibility to identify, locate, and evaluate students who may be entitled to special education services or related accommodations. Next slide, please. Now, there are a number of events that might trigger one's child find obligations. For example, absences from a student, or certainly an uptick in absences, a sudden change in a student's academic performance, or a sudden change in their behavior. If you have knowledge of a major life event for that student, perhaps something involving trauma, if there's been a newly diagnosed medical condition or a change in medical condition, those could all be events that may trigger one's child find obligations. And we also wanted to highlight, you'll see in the final point here, that a medical diagnosis is not required to trigger child find. That just is something for you to keep in mind as something that may trigger your child find obligations. And then let's go to this next slide, please. So when a parent or guardian or school staff or another individual suspects that a student may have a disability requiring accommodations or related services, then a referral should be made for that student's evaluation. Parental consent is required for initial evaluation of a student. And although Section 504 doesn't specify the form with which that consent should take place, it is absolutely best practice that the written consent of parents be acquired for initial evaluation. It's also the case that specific evaluations for the student should be proposed after school personnel review the referral information through an evaluation consent form. So you can determine exactly what would be most appropriate by way of evaluation. And with that, I'm going to transition over to Bettina, who's going to speak a little bit to Section 504 eligibility.
Thanks, Eric. Okay, so let's talk about eligibility under Section 504. So main things to keep in mind, again, when we're talking about these distinctions between 504 and the IDEA, special education, Section 504 is broader. So this is, obviously many of you know this, but this is something to keep in mind. The eligibility is broader than under the IDEA. So under Section 504, there's a three-pronged approach to considering whether a student's eligible. So the first is whether the student has a physical or mental impairment, that's the first prong, that substantially limits, that's the second prong, and the third is a major life activity. So it has to, the question is, does a student have a physical or mental impairment that substantially limits a major life activity? Okay, so let's talk about each one of those prongs. Next slide, please. Okay, so physical or mental impairment, again, very broad, right? So it's any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more of the following bodily systems. And then they're listed here, right? So very broad, major bodily systems. And then the last sort of catch-all category for any mental or psychological disorder, such as intellectual disability, organic brain syndrome, emotional or mental illness, or specific learning disabilities. So it's very broad. Next slide, please. So getting to the second prong of eligibility, that it has to be a physical or mental impairment that substantially limits. So what does that mean to substantially limit? So the definition of a disability must be construed in favor of broad coverage under 504. That's sort of like an overarching theme of Section 504. So in considering whether a student is substantially limited in the performance of a major life activity, the student is compared to the average student of the same age in the general population. The determination, like with special education, is an individualized assessment. However, the term substantially limits must be construed broadly in favor of expansive coverage, as I mentioned. It's not meant to be a demanding standard. And the impairment does not have to prevent or significantly restrict the individual from performing a major life activity in order to be considered substantially limiting. So again, very broad, right? And next slide, please. So then we get to the third prong of eligibility, major life activities. So what are the major life activities? This is a list of sort of the typical ones that you might see in an educational environment or an employment environment for that matter. But it's not meant to be all-encompassing. So it could be broader than this, but these are typically the areas that are considered major life activities under that third prong of eligibility. Next slide, please. All right, so when considering eligibility under Section 504, it's important to note the following. An impairment that substantially limits one major life activity need not limit other major life activities in order to be considered a disability. So an example of that might be a student who has a diagnosis of dyslexia, who has high overall academic performance, gets straight A's, but might struggle with reading, which is considered a major life activity. That student might be eligible under Section 504, even if they're getting, good grades and, otherwise seeming to do well at school. An impairment that is episodic or in remission may still be considered to be a disability under Section 504 if it would substantially limit a major life activity when active. So this might be, for example, maybe an autoimmune disease that flares up. So the student might not meet the eligibility when in remission, but if the student would meet the eligibility criteria when the disability is active, then they might be eligible under Section 504. Next slide, please. Okay, so let's talk about the evaluation process. A student cannot be considered to be eligible for Section 504 until an evaluation has been taken place and the 504 team determines that the student is eligible. But once the student, so let's talk about eligibility. Let's talk about evaluation. So evaluation for Section 504 generally includes formal assessments as determined appropriate based on the presenting need or referral. So when the student's referred to the school's 504 team, the 504 coordinator will determine based on the nature of the referral what types of evaluations might be appropriate. Other things that the evaluation 504 team can consider: grades, other student records, health information, classroom participation and performance. Again, it's broad. It's whatever's relevant, right? In many cases, the school will also seek, but may not require, a release from the parent to speak to outside service providers to gather additional information. Again, the school can't require that, but it can be helpful information for the school to consider if the parent consents. Next slide, please. So there are times when families may present the school with reports from outside evaluators. The school may consider reports from outside evaluations. So the parent might provide you with an outside evaluation or a report from an outside medical provider. So it's important to consider the findings from the outside evaluation, but the school should always reserve the right to conduct its own evaluation. So again, the more information, obviously, the better when determining eligibility, and that information will be helpful. But the school should reserve the right to conduct its own evaluation. If a student had an evaluation done as part of an IEP team process and was determined not eligible for special education services, those evaluations may be used or relied upon by the 504 team, particularly if they're recent, and provide appropriate and sufficient evaluation data to determine 504 eligibility. So folks see this a lot, right? If you participated in IEP teams or 504 teams, a student's determined is considered for eligibility under the IEP team process and is found not eligible, but you have all of the evaluations that were done as part of that process. Those evaluations can be used for purposes of the 504 eligibility, but you want to make sure that they're recent. If they're a year old, you probably want to update them. If there's additional information that's needed by the 504 team, you would want to seek a consent to gather that information. And then another difference under Section 504, there's no right to a publicly funded IEE, an independent educational evaluation, if the parent or guardian disagrees with the school's evaluation. Next slide, please. So who is on the Section 504 eligibility team meeting? It should consist of individuals who have knowledge about the student, obviously, and have knowledge about the evaluation data and information. So particularly if a parent's providing an outside evaluation, you want to have either the person that did the evaluation or someone on school staff that is qualified to interpret the results of that evaluation. And you'll want to have obviously someone who has knowledge about the accommodations and related services that might be discussed. And then anybody else that the parent thinks would or guardian thinks would be helpful for determining eligibility should be included as well. Next slide, please. Okay, so the 504 team review. The 504 team will meet to consider all of the assessment reports and relevant information to determine eligibility and, if appropriate, the necessary services and supports. So here I've listed some questions that are not meant to be exhaustive, but questions that the team might consider or should consider as part of the process for reviewing eligibility documentation. Or assessments. So what is the nature and severity of the impairment? What is the suspected duration of the impairment? How has the student responded to prior interventions? So have prior interventions been tried? What was the response? Were they effective, partially effective, not effective at all? Does the student consistently need extended time to complete assignments or to complete exams? Does the student consistently need significant changes to the curriculum and or the physical school environment? And has the student shown a pattern of negative behavior? So obviously behavior is an issue that comes up in the process of, in the course of the educational environment. And that could be a trigger, again, talking about child find that might warrant a referral for 504 consideration, if not for IEP eligibility consideration. Next slide, please. A couple of things to just keep in mind when we're talking about eligibility. So a child's physician cannot make the student automatically eligible under Section 504. So I've seen this come up, not for a while, but occasionally you'll get a letter from a doctor saying, the students should be in my opinion, or should be qualified for a 504 plan. The physician obviously can make a diagnosis, can make recommendations, can provide helpful background, but it's the school as part of the 504 team process that determines eligibility. Next slide, please. Some other considerations with respect to eligibility, when an impairment does not substantially limit one or more major life activities, a student does not qualify for classroom accommodations. A student does not qualify for classroom accommodations under Section 504. In these instances, the team can discuss with the family instructional strategies that are used routinely for all students. We'll talk about RTI and MTSS in a little bit. But if the student does not meet those three prongs for eligibility, then they would not qualify under Section 504. Next slide, please. I did just want to mention temporary impairments. There's some really good guidance. We've linked one of the guidance documents later in the slide show. But OCR has some now older guidance on Section 504 that can be helpful, both a sort of longer guide that came out in 2016 and a helpful FAQ document. And it does in some of those documents talk about temporary impairments, and there's some other points in there that I wanted to just note in the presentation. So temporary impairment, so OCR has clarified that a temporary impairment does not constitute a disability for purposes of 504 unless its severity is such that it results in a substantial limitation of one or more life activities for an extended period of time. The issue of whether a temporary impairment is substantial enough of a disability must be resolved on a case-by-case basis. So again, the team would decide, considering all of the factors involved, the duration or expected duration of the impairment and the extent to which it limits a major life activity. So I was trying to think of an example of this yesterday. So an example might be if a student breaks their leg and they're going to be in a cast for 6 weeks, would that qualify under Section 504? Maybe, maybe not. It's 6 months or less, as I note in the last bullet here, is typically the sort of gauge. But if the student has a bad leg break and then has surgery and is going to be on crutches or needs some assistance for an extended period of time, then they might be eligible. So again, the point here is just to note that typically temporary impairments do not qualify for Section 504 eligibility, but it's going to need to be determined on a case-by-case basis, taking into consideration the extent of the impairment and the expected duration. Next slide, please. Okay, so mitigating measures, just a note on that. So in determining 504, we're still talking about 504 eligibility. The team cannot consider I trip on this every time, ameliorative effects of mitigating measures when determining how the impairment impacts a major life activity. So examples include medications. We'll talk about ADHD in a few minutes. Prosthetic devices, assistive devices, and learned behavior. So should not be considered when determining how the impairment impacts the major life activities. The exception to that is our eyeglasses and contact lenses, for which the ameliorative effects may be considered. Next slide, please. Next slide.
Okay.
Okay, so I'm going to hand it off to Eric, who's going to talk about the contents of the 504 plan.
Awesome, thank you. So Section 504 requires that eligible students receive a 504 plan. Section 504 doesn't require that those plans be written, but it is absolutely best practice. It is highly recommended that you have written 504 plans just to document the process and the ways in which your school is complying with Section 504. Your Section 504 plan should include the nature of the student's disability and the major life activity or activities limited, the basis for determining the student's disability, the educational impact of any of the student's disabilities. The 504 plan should include the necessary accommodations for that student, including any regular or special education and related aids and services, as well as the appropriate setting for those services. The Section 504 plan should also identify the names of staff who will be providing services or accommodations, and it should include any information about the student's placement. And as we noted here at the bottom, you just want to make sure that the language in your Section 504 plan is sufficiently clear that people who need to engage with it know what is expected of them. Okay, the next slide, please. Thank you. So this topic came up a little bit earlier, but the topic of least restrictive environment. And ultimately, charter schools must ensure that students with disabilities are able to participate in educational activities with students without disabilities to the maximum extent possible, i.e. those students with disabilities should be able to engage in the educational process in the least restrictive environment. Next slide, please. So a few considerations we wanted to highlight. First, dealing with behavior plans. So a charter school should propose a functional behavior assessment or FBA and develop an individualized behavior management plan for a student with a disability when that student's behavioral difficulties significantly interfere with the student's ability to benefit from their education. We also highlighted that Section 504 applies to non-academic services and activities in the same way that it does to academic services and activities. So with respect to those non-academic services and activities, you should keep in mind that students should be afforded the same opportunity to participate equally in those activities and services. And keep in mind certain categories, for example, health services. So you want to be mindful of students who may have severe allergies and any sort of accommodations they may require. Be thoughtful about accommodations that may be needed with respect to extracurricular activities or sports. And then also the categories of field trips and transportation. Okay, I'm gonna go to the next slide, please. So we've talked about the Section 504 plan, some of the information that should be included, the recommendation that it be written, but we also wanted to talk about implementing the 504 plan. So first off, the 504 plan should only be shared on a need-to-know basis. And that will include general education and other school staff that work directly with the student. The school should have a process that ensures that when a student with a 504 plan moves to a new classroom, that the new teacher and support staff review and understand the accommodations in that 504 plan. We definitely want to make sure that there's a level of communication there so there can be consistency in the accommodations provided. The Section 504 plan for a student is not subject to approval or veto by the staff, teachers, admin, or others. Um, and in general, documentation is key. So you're going to want to document the school's receipt of the 504 plan by the parents and guardians and by staff. And with that, I'll transition back over to Bettina.
Thanks, Eric. All right. So let's talk about reviewing the 504 plan. So unlike the IDEA, Section 504 is silent on the specific timing for regular reviews of the 504 plan. So we get this question a lot, right? So is it on the same schedule as the IEP process or not, or should it be? So many schools use the same timing for annual reviews and 3-year reevaluations that are used for special education. Again, Section 504 is silent on the specific timing, but this can make this administratively easier, right, for school districts to put them on the same track. So 504 plans should typically be reviewed at least annually or as appropriate. So if there's a change in placement, you might need to meet more frequently. If a student refuses to accept accommodations, the school should document this refusal and take steps to address it as necessary. So this, oftentimes will come up with older students, so students in high school that will, if they have an accommodation to sit towards the front of the room for attention purposes or hearing purposes, they might not want to feel singled out and sit in the front, so they might, tend to not access that accommodation. Again, you want to handle each situation on a case-by-case basis, try to think about ways, alternate ways to sort of provide the accommodation. But if a student just outright refuses, in addition to obviously notifying the parent or guardian, you want to just document that it was offered, it's in the plan, and the student's refusing it. Again, so can you go back to the previous slide? So students should be reevaluated at least every 3 years, similar to the special education process, to determine eligibility, to update evaluations if necessary. If needs become more significant, or the student appears to require specialized instruction, for example, a referral for special education evaluation should be made. So I make this point just to emphasize that, there's not like two parallel tracks and never the twain shall meet, right? So a student could be on eligible for special education and, at some point be determined not eligible, but then be found eligible for Section 504 eligibility, and it can go the other way. So just keeping in mind, being mindful that if a student's needs seem to increase, it can be a reason to convene the 504 team and potentially make a referral for special education evaluation. Next slide, please. Okay, so let's talk a little bit about behavior and discipline. So like students with IEPs, students with a Section 504 plan are entitled to a manifestation determination review when a suspension or school removal constitutes a change in placement. So typically more than 10 days of removal in one school year. So I'm not going to do a deep dive into the MDR process. I think we've covered that in some other trainings that we've done on student discipline, but just some reminders that the MDR is conducted by relevant members of the Section 504 team and any other individuals that the parent or guardian might want to include, or that might be relevant to the discussion about whatever the particular disciplinary infraction is. And things that the MDR team would consider would be the conduct at issue, obviously, and then the 504 plan itself. So what's the nature of the student's disability? What are the accommodations that are included in the 504 plan? Services, other supports as well. Teacher observations, other observations, etc. And any relevant information obviously provided by the parents or guardians. So again, not to do a deep dive into the MDR process, which I'm sure many of you are familiar with. It's just to remind you that like students that are on an IEP, a student on a Section 504 has an entitlement to the MDR process when they have a school removal that, would trigger an MDR. Next slide, please. As promised, I did want to talk a bit about ADHD in Section 504. So some reminders pursuant to OCR guidance that came out in 2016. Again, older now, but still in effect and helpful guidance that's linked here. It'll be linked when you get the PowerPoint, but also there's a link at the bottom of the URL to the site at the bottom. But anyway, so with respect to ADHD in Section 504, the 504 team, again, cannot consider the mitigating effects of medication. So again, someone asked a question about what does ameliorative mean? It just means you can't consider the lessening impact of those things. So you can't consider the fact that a student has ADHD, but when they take their medicine, they're not experiencing a significant impairment of a major life activity. Okay, so with respect to ADHD, where this comes up often with respect to medication, the 504 team cannot consider the mitigating effects of medication, if that's a helpful way of thinking about it. You must consider all major life activities, not just learning, as I mentioned earlier. Section 504 does not require a medical assessment as a precondition to the school's determination that a student has a disability. So again, school has to conduct an evaluation and consider relevant information. But if the school believes that a medical assessment is necessary, for example, to determine if a student has ADHD, they can't require the parent to go out and get that and pay for it. So that's just something to keep in mind. There are other ways that you can consider whether a student is experiencing ADHD. So the parent's report or observations by the student's teachers and so forth. The charter school should not act on stereotypes and generalizations about ADHD. That's in the OCR guidance. And just a reminder that not all students with ADHD require the same accommodations. So ADHD can impact students' major life activities in different ways. So the team would have to consider the impact and any accommodations and services and supports that might be necessary. And like I said, there's some good information, helpful information in the OCR guidance. So I recommend you take a look at that if you haven't taken a look at it recently. Next slide, please. So OCR will presume that unless there is evidence to the contrary, a student with a diagnosis of ADHD is substantially limited in one or more major life activities and therefore entitled to accommodations under Section 504. For a period of time before OCR issued this guidance, a lot of times the 504 team would, find a student not eligible for 504, but OCR issued this guidance, and the presumption is that a student with a diagnosis of ADHD is substantially limited in one or more major life activities. And it's up to the 504 team to decide what accommodations and supports the student might need. So unless the student is making documented and timely progress with general education interventions and shows no need for accommodations, a referral for an evaluation should be made either for 504 or special ed. Next slide, please. So many students, let's talk about Section 504 and individualized healthcare plans. So this is a question that we get a lot. What's the intersection between an IHCP or an IHP and the Section 504 plan? So many students, as I'm sure many of you know, who are eligible under Section 504 have chronic medical issues that also require an individualized healthcare plan. A student may have both a 504 and an IHCP. Just for folks that are not as familiar with individualized healthcare plans, an IHCP is a written document that outlines the provision of student healthcare services to ensure that a student with medical needs students' medical needs are met throughout the day. So these are services that are typically provided by a nurse or a nurse's assistant. It could be, for example, a student with type 1 diabetes that needs insulin management. or for students who are more medically involved with a trach or a J-tube or a G-tube, feeding tube, services that typically require like nursing support. So just because a student is on an IHCP doesn't mean they'll automatically qualify for a Section 504 plan or that they have a disability under Section 504, but they might, so they could have both. This will determine whether the student's health challenge, so the consideration is, does the student's health challenge substantially limit a major life activity, and whether, because of the medical issue, the student needs special education or related aids and services. So again, it doesn't automatically qualify a student for a Section 504 plan if they're on an IHCP, but oftentimes there will be an overlap, and there will be accommodations that might be needed, and the student will be eligible. Next slide, please. So I did want to talk, we did want to talk a little bit about Section 504 child find, or the intersection between Section 504 child find and RTI, MTSS, and similar support. So as folks are most likely aware, so the use of RTI, MTSS, or similar supports is contemplated under federal law and can be considered prior to referral for special education. So these are services that are provided in the general, general education setting for all students, available to all students. The thing to keep in mind is that RTI, MTSS supports and support structures may not be used as a reason for rejecting a referral or failing to conduct a timely intervention, timely evaluation. So if a charter school agrees that the student might be eligible, it should seek a consent to evaluate whether or not they are also monitoring the student's response to other evidence-based general education interventions. So in other words, it's not okay to just say, like, we're going to try these interventions before we refer the student. If it's appropriate to refer, then you should refer. The charter school may deny an evaluation in response to referral if it does not suspect a disability. However, the basis for denial cannot be that the charter school is waiting to see how the child responds to general education interventions. And it seems common sense, but there's some guidance on this from OCR, so it's worth mentioning that you can't hold up that referral if it's appropriate. Next slide, please. So the school will assess the need to refer for a 504 evaluation or special education evaluation on an individualized case-by-case basis. Things to consider: what is the nature of the disability or impairment at issue? What are the needs for what seem to be the need for interventions versus accommodations versus specialized instructions and/or related services? And the school, of course, if you're trying RTI or MTSS supports, you want to document, what was tried, how long was it tried for, and what were the results? Was there progress made, or no progress made, or some progress made? Next slide, please. So just a couple of examples of sort of like this analysis when you're thinking about, the range of RTI, MTSS, and Section 504 in when to refer. So I just give an example here. So a kindergarten student who has no preschool experience first time at school, is displaying difficulty regulating behavior like during the day and having some trouble during transitions. This is very common, right? So the school could implement general education interventions and monitor progress to determine if the student requires an evaluation. Is this just the student's inexperience, being in a school setting, being young, immature, etc.? So you could do that. But if the school also is informed, for example, by the parent that the student has a diagnosis of PTSD, which impacts the student's ability to regulate, particularly during unstructured times, which is a lot of times during, kindergarten, the school should implement those general education interventions and monitor progress, but also start the referral process, because at that point, the school has reason to believe that the student may have a disability that's is related to the observed difficulties that the school's seeing. So that's one example, and then we have another one in the next slide. So another example, a first grade student is struggling with reading. So the charter school puts the student in a general education reading support group. As a result of participation in this group, the student makes steady and documented progress towards grade level reading, and there's no basis to suspect that the student either has a disability or requires specialized education to continue making progress. So in that case, the school would continue those general education supports and monitor progress, obviously. But if despite participation in the group, the student continues to struggle with reading, is making minimal or no progress, then you would continue those general education supports, but refer the student for an evaluation. So just kind of a couple of examples, that are not so uncommon that we see in our practice, and you may see in yours as well. So just some suggestions on ways to handle those situations. Next slide, please. All right, so I do want to talk a little bit about procedural safeguards. So Eric talked about a couple of these earlier, but just reminders. So Section 504 requires the charter schools develop and implement a system of procedural safeguards to address FAPE concerns, such as identification, evaluation, and educational placement of students with disabilities. So again, similar to the requirements of the IDEA, parents and guardians have a right to notice, an opportunity to review relevant records, in an impartial hearing if there's disagreement. So one means of meeting the procedural safeguards requirement of Section 504 is compliance with the IDEA procedural safeguards. So if you provide parents with a copy of DESE's notice, parents' notice of procedural safeguards, you could use the same form for notice of parent rights, and that would meet the notice requirement for Section 504, and many schools typically do that. Next slide, please. So again, just reminders. I know Eric mentioned these earlier, but they're a good reminder. So your charter school should definitely have designated an individual that functions in the role of a Section 504 coordinator to coordinate and monitor the school's efforts to comply with Section 504. Typically, we'll talk about grievance procedures in a sec. Typically, as part of the school's grievance procedures, if a parent or another individual is aggrieved by feels that the school's not following Section 504, its policy and procedures, there's a grievance process, and typically the complaint would go to the Section 504 coordinator. So you definitely want to, like a Title IX coordinator, make sure that there's somebody that's clearly designated as a Section 504 coordinator. And just a note, like Title IX, some schools have one Section 504 coordinator for the whole school. Some have a Section 504 coordinator for students and one for employees. Again, we are not talking about, we haven't even sort of delved into Section 504 in the employment context, but some schools will have a Section 504 coordinator for employees as well. So the point is to have at least one designated Section 504 coordinator. A notice of non-discrimination, as Eric mentioned earlier. So charter schools are required to provide notice identifying the school's Section 504 coordinator in notifying students, parents, guardians, applicants, and employees that it does not discriminate on the basis of disability in the admission or access to or employment in the school's program or activities. And then there must be grievance procedures. So your school should have a grievance policy, a Section 504 policy and grievance procedures that establish a process for 504 grievances. So if you don't have that, you want to get that. It's always good to review it at least annually. And then just a reminder, your grievance policy and procedures should include this, but there's a prohibition against retaliation for any individual who complains formally or informally about a potential civil rights violation. And that's all civil rights violations under federal and state law, but including Section 504. Next slide, please. So what are the risks of non-compliance with Section 504? So being out of compliance with Section 504 or other civil rights laws and policies might result in someone filing a complaint. So a complaint with court, so you could get sued, lawsuit. Someone could bring a complaint to the BSEA, Bureau of Special Education Appeals, just as they could with an IDEA complaint. Someone could file a complaint with the Office for Civil Rights, which the U.S. Department of Education's Office for Civil Rights has authority to enforce Section 504. So individuals can file a complaint with OCR, or they could file a complaint with DESE's problem resolution system. So a number of avenues for folks to grieve any perceived violations of Section 504. So it's important to have a policy, have your staff trained on the policy and procedures, and to follow them. Next slide, please. So that's just a reminder to everyone. You want to make sure that you're reviewing, as I noted, your 504 policy and grievance procedures. You want to also review, obviously, your other non-discrimination policies and grievance procedures. That's always important to do on a regular basis as well. But also take a look at your policies and practices, other sort of related policies and practices, right? So policies and practices regarding concussion protocols, life-threatening food allergies, field trip policies, all of those things that might in some way intersect with Section 504. You want to be reviewing those medication administration policies, again, for nursing staff and others, important to review regularly as well. Next slide. All right, and with that, I'm going to hand it over to Eric. We're going to we have a little bit of time, so we're going to try to get to some of the questions that folks submitted. We're going to start with some of the ones that were submitted with registration, but we'll get to some of the ones that people submitted today. So with that, I'll hand it over to Eric.
Yeah, thank you, Bettina. Okay, so to get started with some of the questions that we received, I'll give kind of a couple that are related and kind of came in for us. But the question around, does a 504 plan have to be accepted by a student's parent or guardian in order to be active? And so to answer that, we first want to highlight that evaluation of the student has to occur before the provision of any Section 504 accommodations, and you do need parental consent for evaluation of a student. And as we indicated kind of throughout today's webinar, you want that consent to evaluation to be in writing. The benefits of having it in writing are that you now have this documented, which is always a best practice. And it also clarifies for the parties what precisely is going to be assessed for the student, what is going to be evaluated. That's definitely information that you want to keep clear. A related question that we received is, okay, so what if the parent consents to an evaluation, but then ultimately disagrees with the 504 accommodations that are proposed by the school? Ultimately, you want the school and the parent to be in alignment. You want parental consent to the accommodations being provided to a student. And so in the best case, the 504 team would meet and you'd be able to discuss the parents' concerns and come to some sort of agreement in that process. If it's not the case that you're able to come to an agreement or the parent disagrees with the accommodations to be applied to their student, then the school really needs to evaluate things on a case-by-case basis and consider how to best balance the parents' wishes with the school's obligation to not discriminate against the student on the basis of disability. And so that's going to be something for schools to consider on a case-by-case basis as it pertains to individual students. And if it's the case that students and parents still can't come to agreement on what might be most appropriate for accommodations, it is possible that you could then move forward to find some sort of resolution through the BSEA, for example. So those are some options there. And I think, Bettina, are you ready to kind of take on another question?
Yes,
Awesome.
thank you. We get some great questions. So I'm glad that folks are asking some of the sort of all the hits, like the most common questions that we get, because I think if you're asking the question, other folks probably have the same question. So the next question that I'm going to take is sort of another two-parter. So how do recent changes to Title VI impact obligations of charter schools with respect to enforcement of 504? So reminder to folks that Title VI is a federal law that prohibits discrimination on the basis of race, color, national origin, which includes actual or perceived shared ancestry or ethnic characteristics. And then the second part of the question is, how might the current presidential administration's actions impact charter school students in Massachusetts? So first, as Eric mentioned at the beginning of the presentation, there are no recent or planned changes to Section 504 at the moment. I will say I do think that we're I do think that we're likely to see less enforcement by OCR of disability related matters. One, because DOE is supposedly going away and it's not clear, who will be taking over the enforcement activities. But also that OCR has stated that it has shifted its focus to dismantlement of DEIA, the A being accessibility initiatives. And it's focusing more on shared harassment based on shared ancestry and separation by sex and athletics. So all of that is to say that shift in enforcement priorities, although OCR has said at different points in time that disability discrimination is still a priority. I think we're, at least I seem to be seeing less enforcement activities with schools, which I don't know if that means there's less of it or they're just not, it's not an enforcement priority. And I think it's likely the latter. The second, as a practical matter, sort of related to the scaling down of US DOE generally, is that OCR, as folks likely know, has really reduced staff significantly, including closing offices, which obviously impacts their enforcement activities. So I think we'll be seeing less enforcement in the area of disability discrimination, including Section 504, in longer times in terms of response, both in terms of responding to initial complaints, but compliance matters taking a longer period of time. So if you do get a notice of a compliance action, requesting documents and all of the things that are involved in that, I think the timelines for resolution, I think, will be longer than they have been historically. But again, just a reminder that charter schools, you all are just reminded that you're required to avoid discrimination on the disability also under state law and charter school regulations. So, as folks know, DESE and the Mass AGO have emphasized the state's commitment to anti-discrimination to individuals based on any protected characteristics. So, there's still obviously, enforcement at the state level for all protected classes. And so I think, we'll continue to see enforcement in the area of disability discrimination in schools, probably more on the state level than the federal level. So that's a long-winded response to the question, but I hope that answers the question. I'll hand it back to Eric. Do you have some other questions?
Yeah, I do. So as piggyback on what you were describing, Bettina, if someone just wanted a clarification for what OCR is, OCR refers to the Office for Civil Rights within the U.S. Department of Education. And OCR, or the Office for Civil Rights, is responsible for enforcement with respect to Section 504. So just wanted to kind of highlight that for OCR. And then another question that we wanted to highlight, being mindful of the time we have left, was the question, is there a criteria that differentiates eligibility for Section 504 versus an IEP? And yes, there are differences there. So as we kind of discussed today, for Section 504 eligibility, we're looking at whether a student, for example, has a physical or mental impairment that substantially limits a major life activity. So that's the criteria for Section 504. And considering whether a student might be eligible for an IEP, there is a different set of considerations there. So first, you need to consider whether or not the student has one of, I believe, 13 enumerated disabilities. If so, you need to ask the question of whether the student is making effective progress in the general education program. If not, you have to ask whether that lack of progress is a result of the student's disability. And if that's the case, that the student's disability is leading to their lack of progress in the general education program, then you have to ask the question of whether the student requires specialized instruction or related services to make effective progress. And so if you kind of go through each of those steps, the student might then be eligible for an IEP. I see we're running up towards the end of our webinar time, and there are a variety of questions that we received. And so we plan, as Bettina mentioned, to prepare some answers to those questions and circulate those so that people would have an opportunity to get a little bit more information. But with that, yeah, we'll ultimately kind of thank you all for your attention and for your fantastic questions. Bettina, please feel free to chime in if there was anything else, but we thank you all for this opportunity.
Thanks, Eric. I also wanted to say thank you to the MCPSA for co-hosting with us. Again, it's always a pleasure to do these learning events. And I thank you all for taking time to join us today. So thanks very much, and we appreciate your time.